And welcome back to America Right Now. Former President Trump's second impeachment trial starts Monday, even though Democrats don't have the votes to convict him again. So what should his strategy be? And can Trump come out a winner here in more ways than one? Let's discuss with our legal panel for this Saturday. Thane Rosenbaum, he is the Distinguished University Professor at Touro Law School and former assistant to President Trump, and White House Cabinet Secretary Bill McGinley is here. He's also the principal of the Vogel Group. Okay, guys, Professor, we're going to start with you. There's been a lot of chatter about the theory of the president's case. Originally, Trump wanted to focus on voter fraud allegations. We are told they have shifted away from that strategy. Now, I know you're a Democrat, but if you were defending the former president, what would your strategy be?
Well, Tom, the first thing I would say is this body, the Senate trial, has no jurisdiction over my client, who is now a private citizen living in Palm Beach and living his life. The Constitution says nothing about prosecuting former presidents under the Constitution when the primary remedy for the impeachment is to remove the president from office, which has already occurred. Secondly, does that mean that the Constitution does not apply to presidents? Are they held to such a higher standards that his or her free speech rights are essentially canceled? We dispense with due process because this is the president of the United States. This man was delivering a speech, yes, emotional, but there's nothing wrong with emotional speeches. They're not uncommon for him. It's the same speech he gave for 5 years. So it's a spontaneous emotional appeal expressing his uncertainty, his doubt. Again, I don't think he should have ever used words like stolen or the language of a stolen election obviously was heated. But the basic principle of speaking in emotional terms in a political rally is something that's protected under the First Amendment. And the question is, why should the impeachment procedures of the Constitution apply to the president, but not the First Amendment?
So the Democrats are saying, Professor, that he was basically like a loaded gun, that he is the person who incited an insurrection to overthrow the government of the United States. That is basically what they're accusing him of doing. You don't see any constitutional or presidential way that they can prove that case.
Tom, we're in very dangerous territory here. I understand this is a political trial and not a legal trial, and we know that because politicians have essentially created the rules. But, you know, the First Amendment has protected civil rights activists, anti-war activists, flag burners. Progressives and Democrats should be very careful here because the First Amendment has historically protected them in these situations. And I do not think that the language of the president meets the legal standard. I know this is not a legal trial, but the legal standard of incitement of imminent lawlessness when two things are present here. First of all, he said peacefully and patriotically, make your voices heard.
Right.
And secondly, it's possible there's evidence that the 100 people that have been arrested had planned to commit the crime anyway. So you can't, this thing would have happened anyway. So it's not as if he lit the match. They came with this purpose. Unless there's evidence that he knew that they were planning this and lit the match, I just don't see how he can be stripped of that right to speak to them.
Yeah, and there's a timetable issue where there were people who had already breached the Capitol even before he finished speaking. Bill, I want to get to you. The president's team decided not to have him testify. I happen to think that that's a very good move. You know, much of this, though, again, you know, the professor says it's not a legal trial, it's a political trial. So this is about leveraging it from a communications and a political standpoint. How does the former president and Republicans come out of this perhaps looking stronger?
I think, number one, they need to follow the professor's advice and say that this is an unconstitutional proceeding. The former president is a private citizen now. And under the old British common law at the founding of our country, the British were able to impeach private individuals. The founders wisely said, we're not going to do that. I understand that there's one precedent in the past, but that was not for an elected official, such as the President of the United States. I also think that they need to hammer home the fact that there was no due process in the House proceedings. It was a snap impeachment. There were no hearings. The president's attorneys did not have an opportunity to cross-examine witnesses. There's no factual record that the House will be transmitting over to the Senate. And I think that the president's defense team really needs to focus on what the House managers say and trying to lay out. And I think it's correctly characterized as an emotional argument about the riot that happened both inside the Capitol and on the surrounding grounds. But I think they also need to be prepared to point out what they don't include in their arguments, because they will selectively quote from the president's speech.
Right.
They will try to selectively quote from other evidence. And I think the president's counsel is going to need to provide context for that. Finally, I think they need to expand the universe. Presidential value here and the precedent that this is going to set, I think, is very dangerous. The House impeached him while he was in office. They had every right to do that, even though they didn't afford him the due process that past impeachment processes have given presidents. But nonetheless, we are seeing a snap trial as well. There are still ongoing criminal investigations. We don't know the full facts surrounding what happened on January 6th and the days leading up to it in connection with the people who stormed the Capitol. It may be proven that there was no connection to the president or anything else. And so rushing this trial, I think, is very dangerous for future presidents. And I think, once again, this is an example of the Democrats setting a precedent that they're going to come back to regret. Whether it was, using the nuclear option to make it a majority vote for the confirmation of judges, and now they're using reconciliation and threatening the filibuster.
Right.
The pendulum swings in politics, and the precedent that they're setting here in the first 100 days of the Biden presidency, I'm concerned is actually going to come back and make a lot of the constitutional safeguards that we have built into the system erase them from the procedures.
Gentlemen, I'm out of time, but when we have you back, I do want to talk about this issue of whether or not Congress can pass a resolution barring former President Trump from running for office again under the 14th Amendment. I think that is actually where this is going to go, because they don't have the votes to convict him in a Senate trial. But Bill McGinley and Professor Rosenbaum, always enlightening. Appreciate you being here.
Thank you, Tom.
Thanks for having us.
Up next, the latest in our Taking Back Our Schools segment. This week, we focus on a critically important issue of school choice. Stay tuned.